having taught on the faculty at the Florida Judicial College. He frequently writes for legal publications. He's the author. He's officially listed as the ABA Journal blog Orlando Mediator. He's experienced in mediation and arbitration and multi-party complex civil litigation in state, federal, and appellate courts. And he's also served as a general magistrate in the 9th Judicial Circuit of Florida. I also want to take just a minute and thank our sponsor, University of Florida, Levin College of Law, and we appreciate the opportunity to, Levin College of Law Institute for Dispute Resolution, and I appreciate the opportunity to have them co-sponsor our webinars. Okay, here we go. So, on to our topic, guess who's coming to mediation? And the way we have this broken down is I'm going to spend a little bit of time talking about our state rule and some of the changes that occurred back in 2012. And then I'm going to turn it over to Lawrence, and he's going to share some information with you about the rules in the appellate process, appellate mediation, and then Dom is going to have an opportunity to talk about the appearance rules, primarily the appearance rules, within the context of the federal courts. So let's take a little bit of a journey here through the background of the rule. The rule has been in effect since 1987. So we've had the appearance rule for quite a while, and the way that it's kind of a backdoor into authority. We basically access authority or deal with authority here in the Florida Rules of Civil Procedure by virtue of the appearance rule. So that is 1.720, and basically what we had is court entering orders the matter to mediation and directing parties to appear. And then we've had a definition of appearance. And then basically, if there's no authority, there would be no appearance at the mediation and an opportunity to impose sanctions. One of the things about the background of this rule that's important to remember is that it applies only to court-ordered mediations. So if you want this rule to apply to either pre-suit mediations or some kind of other mediation by contract, you need to reference the rule and make sure that you incorporate the provisions of that rule. Let's see. So now let's take a peek at the text of the rule. We can see that obviously the party has to be present, the party representative with full authority to settle. None of this is new. This was all in the prior rule. Parties counsel, if any. And then, of course, subsection 3, which references the representative for an insurance carrier for any insured party. And again, it incorporates the requirement to have full authority and specifies what would constitute full authority. And then that full authority is required without further consultation. And then we take a peek at Rule 1.720C. This was added in 2012, in the changes to 2012, and it basically detailed what full authority was. It had to be someone who had the legal capacity to sign an agreement, and not only that, that individual had to be the final decision maker on all the issues relative to the case. So it's certainly conceivable that you might have to have two individuals present to fulfill these requirements. An example might be in an employment case where you might need a corporate representative or somebody from HR who would deal with various employment issues or maybe opportunities that would come up regarding settlement for the need to have a neutral letter of reference or something to that effect. And then, of course, if there were insurance coverage, then you would need someone from the insurance carrier, an insurance carrier representative. So one of the things to explore when you're looking at who is the party representative is you need to look at both of these elements and make sure that you're going to be able to satisfy both of them in the preparation of your case for mediation. So another thing that happened in 2012 with the changes is there was created what's called a certification of authority. And one of our mediators, who's one of our principals, Larry Watson, was actually played a part in the promulgation of this rule and the certification. So in essence, what we have here is a requirement that you file a notice and certification with the court. It has to be done prior to the mediation. The rule specifies 10 days. You have to basically list the identity of the party or the corporate representative or the insurance representative, and in essence certify that you are filing the notice in compliance with Rule 1.720B. It is obligated, or I'm sorry, each party is required to file this. And then the little note, of course, unless stipulated otherwise by the parties. So that language certainly creates the opportunity for folks to get together in advance of the mediation and agree either to waive the requirements of this certification of authority or to have the opportunity to maybe modify them somewhat depending on the particular needs of the situation. So what we've done is we've created our own form internally, and of course we don't really have the need for this, but it's something that we have created for the use of the attorneys that we work with, and I'm sure most of you have a form like this now at this point in your office, but this is just an example of what we would consider the compliance with the rule.
Michelle, it's Lawrence. Have you seen many of these being provided to the mediator at the outset of the engagement?
You know, I haven't. It's funny, you know, I'm going to talk a little bit about that later, Lawrence, but I've really seen very little change since the 2012 amendments went into effect. I mean, I rarely hear anything about the notice or the certification of authority. I rarely see them. I rarely hear any discussion about full authority or failure to appear. So really, I haven't seen much of a change. Have you seen much of a change in your practice, Dom or Lauren?
That's been my experience as well. Dom?
I haven't seen it either. I think for the most part, in most of the cases, it's almost like an unworkable rule for them. But it just works out that way, it seems. The person who comes here has a certain amount of authority, and that's all that there's going to be on the file. It's been round-tabled, if you will, or it's been gone through the claims committee, and it is what it is, and the person who's here has it, and that's the authority, but I've never seen any certificates.
Well, and one of the things that was changed a little bit was the sanctions section, which is subsection F. There always was the opportunity for sanctions, but in this subsection, they put a little bit more teeth in it. Basically, they said that the court shall impose sanctions, and it also specified what the sanctions would be, that it would be costs and attorney's fees. And the other thing is it sort of took any obligation off of the mediator. The new rule in connection with the notice and certification kind of put the issue in front of the court and between the parties, which is where it really should belong to begin with, because as mediators, we really are not in a position to violate confidentiality in the context of the mediation process by discussing with the court or some third party, you know, what transpired at the mediation regarding any potential discussions about full authority. So that was really one of the primary motivating factors for the changes in the rule, was to kind of put the fuss where it belongs, which is on the parties and in connection with the court, and kind of leave the mediator out of it. And one other thing that was done with the new rule in terms of the certification is if there's a failure to file the certification, or if there's a failure of the individual named in the certification to appear for the mediation, then what you have is a rebuttable presumption of non-appearance. So that was some additional teeth that was put in. And so we had some, anticipated or potential intended consequences. And the intended consequences were to engage the attorneys in more of an upfront discussion about authority and about who they were going to be bringing to the mediation, and maybe even open the door for them to discuss these issues with the mediator. And I have conferred with a couple of my colleagues, and that has in fact happened, where mediators might, even on the front end before the actual mediation occurs, have some conversation with counsel about, who really are the best people to bring to the table with respect to full authority. And then that kind of feeds into the other element that's on our slide, which is structuring the mediation process in a way that it best fits the parties' needs. And again, not that I've seen much of this, but it also opens the door to judicial intervention if need be, since the parties are or should be thinking a little bit more in advance about who's going to be coming to mediation. It also opens the door to the opportunity to have the court involved should they have some objections or problems with who's going to be coming to mediation, how the mediation is going to be structured, whether it's premature for mediation, so they might want to defer or dispense with mediation altogether. So then this kind of gets into something that we were talking about a little bit earlier. What actually are the consequences? We already talked about how the mediators are really no longer the authority of police. It's really an issue between the parties, and one that can certainly be taken before the court. And as far as I know, and as far as Lawrence and Dom know, we don't have any case law on the issue. It really hasn't had a big impact on how the lawyers practice.
Now, Michelle, is that because people don't seem to be aware of the rule, or is it that complying with it is fairly simple?
Well, I think it's just because complying with the rule is pretty simple, and I think there's almost an acceptance too within, among litigators who participate in mediation a lot, that the practical reality is sometimes you really won't have the person with full authority at mediation, and sometimes it is going to be a two-step process. This is something that was discussed at the FJA seminar last night. They were talking about how sometimes you're not going to have the insurance adjuster there with the full authority. There is going to be someone he or she is going to have to connect with by phone based on how the negotiations go. So, but I haven't heard of much in the way of sanctions. Have you guys, Dom or Lauren?
Well, I mean, that's just the difference between the realistic approach as to, to me, the rule in and of itself is idealistic, and it's just not practical. It just doesn't work that way in most of those mediations. So I think that everyone has come to terms with that, and where it's almost business as usual, if you will.
The sanction piece, first of all, of course, courts are reluctant to even hear from the parties about this kind of thing, because if you can't agree on the process of getting together, then things aren't boding well for trial. The sanctions that I've heard of, and I'll get into some of them in the other contexts of the appellate rule, can be draconian, but likely they're going to cover the cost of the mediation. If anything, that will be the likely result if you see court intervention, which again is not favored.
So just a couple things to remember about 1.720. You know, people can sometimes get confused. You know, there is a difference between whether you're a B1 or a B3 participant. You know, obviously if it's a named individual defendant in an action and they are insured and they're represented by an insurance company, then that's a B3 participant, versus like a coverage dispute where the insurance company is a named party, that's a B1 participant. And again, it's important to name specific individual or individuals, and I put plural there because sometimes folks are not really sure who is going to show up, particularly on the defense side, and so to kind of cover themselves, they may want to include a couple different names of folks that would be representing the corporation or the insurance company. Sanctions are not against the lawyers, they're against the parties, and because this is a procedural rule, it does not apply in federal court cases, and we're going to hear a little bit about rules that are applicable in federal court cases from Dom in just a few minutes. And of course, keep in mind that this requirement can be modified or waived if the parties agree, but best practices would be that you go ahead and file this with the court. Since the notice and certification has to be filed with the court, you might as well file a stipulation if you're going to waive compliance with it. And also keep in mind, too, that there's been some MEAC opinions recently on this, that for the most part in state court, mediators are only going to report settlement or no settlement, and we typically don't get into reporting exactly who was present at the mediation. You're going to hear a little bit about some of the differences in those types of reports in federal court, though, and Dom is going to address those. So I think that really concludes my section, and now we're going to hear a little bit about the rules in appellate mediation.
Thanks, Michelle. You're doing a yeoman's job. I know you've taken over the role of moderator from Sandy Upchurch, who's ascended to the bench in Volusia, and we're very happy to have you conducting this morning.
Well, so thanks. This is my first stab with this technology, so
you sound good.
You can let me know when it's all finished how I did.
So the corollary rule really came about as a result of my noticing that Rule 9.720 didn't match up with 1.720, so I went ahead and contacted the Appellate Rules Committee and told them that it likely should match because we're dealing with cases that might have already mediated under those circumstances in 1.720, and why should it be any different? And just to give you a little bit of background, the appellate mediation process had come into Florida from really the 5th DCA and has still predominantly been a process that the 5th DCA is utilizing. I'm really not aware, only anecdotally, of other district courts that are they're considering sending cases to mediation in some formal way. But the 5th had a pilot program in 2001. Many of us became certified under that pilot program to mediate those cases. And I should mention that really about a third of those cases do seem to go away at some point following the appellate mediation, and that takes place before briefing and when that significant expense is incurred. So the certificate of authority is really the same as you find in the rule Michelle just covered. That rule had dated back to discussions at the ADR Rules and Policy Committee back in like 2006. That rule became effective in January of 2012, and the appellate corollary rule that you find here is now effective as of last month, so it was January 1st of this year. And so really it follows and tracks the language in regard to appearance, which is kind of our theme today. But I should mention in the procedures there is always a reference to those mediations that involve governmental entities, and the fact that someone who comes in a city or state or local government type mediation is going to have to go back to a decision-making body. They really don't have the same kind of quote-unquote full authority that someone might have from a company, from an insurance adjuster and the like. So they're going to have to go back, probably have a shade meeting, and get that body to accept the deal that has been made at mediation. So I just wanted to point that out. In both these rules, there's a reference to Chapter 286, which is, of course, the Sunshine Law, and that part of it is a little different for those of you that deal with governmental entities. And as far as the appearance, really, it's my preference in appellate setting that we do have trial counsel, unless they're just a pain in the neck. And I know some appellate lawyers feel like the trial counsel is drinking too much Kool-Aid if they won, and they'll never come to the table because they want to stand on the result below. But I do find that it helps to have some history, to understand what happened at the trial, to understand some of the objections that were made, even some of the things that happened during the discovery in the case. And it does help to reveal sort of the parties' positions and where they think they're going from here. And I think they're not required. It really says the parties' trial or appellate counsel. There's only one counsel required to appear. But as a mediator, I find it helps to have some history. Sometimes the appellate counsel's just been engaged. They haven't had time to read the record. The client hasn't paid them to read the record because they're not yet briefing. And some people want to check the box and get the process over with and keep on winning. But really, it's a great process I wish more Florida lawyers would utilize. And at least it gets you thinking about what your best arguments are on appeal and what your weaknesses are and what you might be exposed to. And particularly with a client that might have a bent on getting something reversed that could affect the entire industry that they're in, if it's auto insurance or something large like that, that it could have some adverse effect on other pending cases. So these are all things to think about with appearance and who's coming to your appellate mediation. As I mentioned about the sanctions before, they're different in the appellate context. You have the striking of briefs, which can be very draconian. You have the elimination of oral argument as a sanction. Now, most appellate attorneys will tell you they don't know really how much the oral argument makes a difference, but a good one can make a difference, I think. So, that could be I've never heard it happening, but that could be a choice for some shenanigans at mediation in regarding to attendance, the elimination of the oral argument, and of course dismissal or an affirmance of what happened below. Again, I've never heard of these happening. The Fifth's program did not have sanctions spelled out of this before. So again, this rule just came into effect. I don't expect, and I hope there won't be case law on it, because I want everybody to be cooperating and having the process have a chance. And I think that's one of the things that in all these attendance rules, we want the decision makers present because they're the best people that can make and self-determine the outcome of a case. So if there are sanctions and people are using this appearance and attendance type rules as a tactic, it doesn't bode well for having a successful negotiation. So we really don't want to impede the settlement by having a problem arise on the day of. Somebody couldn't make a flight, somebody that was supposed to be there or said they were coming is not. We'll go along with the parties because we want to see a settlement, and we want to make the day productive, and we want you to exchange the information under the confidential context that mediation has, so that you can, if not settle the case, at least leave there more educated about what your options are.
So Lawrence, in essence, the focus needs to be on getting the right folks at mediation and then doing the best that you can at mediation and not necessarily looking to penalize someone.
Right. I mean, we all in Florida have different styles of practice. I go out sometimes to the hinterlands, and it's very warm, and people are doing things with a handshake. And then there's the cliched big city types that come in, and some people pro-hawk in from other jurisdictions, and they have their own idea about mediation being an adversarial process. And I think certainly there can be good advocacy in a mediation. There can be things raised that were saved, and I always say don't save anything for trial anymore, because your mediation is your best day to make a difference and have somebody look at the case differently, and you never know what's going to happen in trial or whether that piece of evidence might just be excluded. So it's it's a time where these rules, they're technical. You can try to hang somebody by them, but the court's not going to look favorably upon something like that. And I think they're really designed to have people make sure they look at what kind of case they're going to attend, and have it roundtabled and have a strategy going into mediation. I realize all of us are very busy, and I remember in the trial practice running from calendar to calendar, from fire to fire, from case management to case management, from pretrial to pretrial, and you don't have the time to, sit down and really have a meaningful discussion until maybe the day before or a couple of days before the mediation, especially if someone's out of town and flying in. And this, 10-day requirement really kind of wakes you up out of your daily fire putting out, and just come and have a discussion with somebody who's going to be with you at your side at the mediation. So it's particularly important in cases that have insurance or even excess layers of insurance, and that's one thing that the rule doesn't really cover, because it talks about the legal capacity to execute a binding agreement, but maybe that includes somebody in a different layer of coverage in the case that involves insurance. So go ahead.
And then we have a certificate of authority in the appellate mediation as well, right?
Yes. So it's the same kind of form, but in this one, you really want to also be aware that the appellate courts want a summary provided to the mediator. Now, again, this is an aspirational thing from a practical standpoint. We get summaries the night before, sometimes day of, sometimes if someone's diligent, it can be as far out as the 10 days. But these are things that help us understand where the parties are coming from, and we hope that they're more than a reconstituted summary judgment argument. They hope that they give us some insight into the history of any negotiations that have taken place. And with regard to the certificate of authority, that it lets us know who's coming. If there's somebody, it's a CFO of a company, it's more than just a third-party adjuster, that somebody's coming that understands and has experience with a catastrophic type case or a wrongful death. This helps us to get the process moving when we get into the session. So, if you're filing them, I wouldn't mind knowing who's coming. You can copy the mediator; it's not required. Sometimes we check the dockets. Many times we have no idea whether the parties even complied with the certificate. And again, we're not, as Michelle said, the authority police. But it may be that knowing who's coming, if we've had experience, particularly with a particular company or an adjuster, might help get things moving, and maybe, as Michelle suggested, have an advanced dialogue about the settlement or potential settlement of a case. So it's something, again, it's a new rule. It's going into the third year, and I do see them occasionally provided to me as a courtesy, but this seminar was kind of to wake everybody up as to the existence of these rules, and to also, just suggest that while they may not be used in a strategic way, they do help to inform us about who's coming. Now, Michelle mentioned some federal rules, and I was going to go ahead, since I'm sort of in the middle of the state, take advantage of informing you about a few things up here in regard to the Middle District. We've had a court annex mediation program in the Middle District of Florida for many years. The rules there are, I think they were last amended in the 2009-ish area, and they are really a little bit different in that they give some flexibility. First, I just wanted to say that the Middle District has a aspirational thing about mediation on their website. The rule really it includes all kinds of things that we do use in mediation, but I think it's spelled out here as sort of suggest alternatives, analyze issues, question perceptions, use logic. Oh my gosh, logic, remember that, Michelle? Conduct private caucuses, stimulate negotiations between the sides. These are things that mediators do. They're not necessarily always spelled out, and I thought this was kind of a nice summary of what mediation means here in the Middle District. As far as the scheduling of Middle District mediations, it's funny because I hadn't looked at the rule in a while, and on the next slide it says, unless provided by order, the conference shall take place in the United States Courthouse. Now, I don't think I've ever conducted a mediation in the Middle District in the United States Courthouse. Has anybody?
No, never.
Yeah, and I don't even, I know it's a beautiful courthouse we have here, and if you haven't been in it, the stained glass windows are astonishing, but I don't know that that is practical. It's also where you have to leave your cell phone behind, so if you have to call somebody for that additional authority, it's not going to be too easy. So I don't know why that's in the rule. I really never seem to be anywhere other than our firm or the law firms of the litigants when we're doing those. So it's interesting, but it's in the rule. Now, the party attendance requirement in the Middle District does talk about excuse by the judge in writing. And so unless otherwise excused by the presiding judge in writing, then people are required to come, and they spell out the various folks. Again, I've had many of these where people last minute have not been able to come, or there's been some change in the person that was coming. I haven't found it to be a problem. They do mention the failure to comply with that attendance or settlement authority requirement could subject to sanctions. Again, I've not heard of those happening in any case that I've been involved with or anecdotally. So it's in the rule, just know it's there. If you look sort of at the next part of the rule, it's the next slide about the mediation of a case where there's an absent party. It really says that the mediator, and in many of the state rules we have control of the process. So it gives us this discretion really to proceed, and I think that's what we find in our firm, that our mediators are flexible. They don't want to impede a settlement that could otherwise take place, and they're not going to stand in the way of that. And I think my colleagues would agree on that. Michelle?
Yeah, definitely.
Well, yeah.
The goal is to try to settle cases.
Right, you would certainly go forward with the mediation, but I have a different take on whether or not we have to report people that don't appear in the Southern District. But I'll talk about that when I get to my end.
Right, and that seems to be a different animal in the South there. The other
different rules as well. Yeah.
Yes.
Rules.
Yeah, and a newer rule that Dom will comment on, which is another reason we're having this presentation today. Now, I would be remiss if I didn't mention our complex business court here in Orlando, which has been around, I guess, over 10 years now, and there are similar complex business litigation divisions in South Florida as well as Hillsborough, and these were based on the North Carolina Business Court, which I think was pretty much an experiment in the National Conference of Circuit Judges that, really was successful in trying to get some cases that may have ended up in divisions where they would clog up a division or slow down the dockets, and we've had a very good success record here, almost like in federal court. There's a track, a very specific business court procedure, which they call BCP, and these rules include mediation. So Rule 8.3 of the BCP really is the first mention of mediation. And on the next slide, you'll see that it's also a 10-day requirement that before that mediation conference you should deliver a summary of the facts and issues. Again, I don't know that I get those 10 days out. In fact, our engagement letter may specify something as few as 5 days, because we're also running from case to case, and we want to have time for the issues in your case to be fresh in our minds. But it does help when I'm provided those summaries in PDF form, much as you would submit a brief to a judge now in the e-portal. When you provide us with these detailed summaries, they do help us to kind of get our hands around where the case is going. We can call you if we have follow-up in advance of the mediation, and try to prompt a dialogue as soon as we get to caucus. So these are things that are in the business court rules, and they include, again, the identification of a business representative. In this situation, these cases are fairly commonly about small businesses that have officers that are attending, and one of the unique things about our business court is it also requires a personal attendance of a officer of a company, a defendant, or a plaintiff in the case management conference, and our judges find that helps to get them early on realistic about what a case that they filed how it might be determined. So again, with the business courts, the attendance requirements have some sanctions in them. I have not heard of them being implemented, but there is a a possibility if there's some things that happen with the run-up to mediation and someone doesn't attend that may have been promised and things go south. This is a possibility. The business court here has been fairly strict, depending on the presiding judge, about the BCP and the compliance therefore. So I think that you got to watch out with the BCP. You'll hear some of our business court lawyers in Orlando. They often have seminars, particularly on those procedures, because one trip up in there could, result in something not good for your case. So these are things to just be aware of in terms of your practice. If you find yourself being removed to federal court, great, you're back in the Middle District, or you're in the Tampa or Orlando divisions. Those are other rules that you'll avail yourselves of. But just be aware that these procedures also exist in some of the other counties in Hillsborough, Dade, and I believe that they're in Fort Lauderdale as well. Yes.
I see that good faith requirement kind of thrown in there too.
Well,
that's
is
a
there
whole
such a thing?
That's a whole nother hour webinar right there. Good faith.
It is, and I think we often get asked as mediators, why aren't they here in good faith, or they're not here in good faith, or I'm going to sue for bad faith, or and I don't think you'll find in the mediation context a really good definition or an enforced definition of what that is. Showing up is half the battle, right, Dom?
I don't think there is a requirement in the Florida statutes that you mediate in good faith. And there's case law that basically says you can just walk into a mediation and say, no, I don't want to offer any money. That's my position on the case. So I don't know what settlement negotiations are in good faith if you just come in and say, no, I'm not going to negotiate. I don't owe any money. And I know there's case law on that, but I don't think the statutes require good faith in and of themselves. Most of them are in the court orders that require mediation, referrals to mediation.
Yeah, that's right. And there is no statutory good faith requirement in Florida.
Yeah, and this is something, again, if you're going to go down that road, likely you're not going to settle the case that day. What I always encourage people is to wait and see. They might have a distrust of the other party. They might be disappointed that somebody didn't come that said they were coming. But there is always that telephone, and we do impress upon the folks in our caucus to go and get that very last authority that they can get for that day. And that may be the end of the discussion for that day, and that case may not settle that day. But it does get sometimes a discussion going at the home office of the people making the decision. They realize that they haven't put enough reserves on something, or that they have to go back to a founder of a company or somewhere else and get that discussion going, and then we find sometimes within a couple of weeks of having met that a case will go away. So it really, if you're going to start hollering and pounding the table about good faith and things like that, it's likely that we're going to have a short day. And I don't know until such time as a high court explains to folks what that participation means, that there really is going to be anything to be done with those words. I think they're aspirational at this point. The last thing I wanted to touch on is the Northern District, and there was a time when you had to certify as a member of the bar in the Northern Middle District by taking a particular application and then do a separate exam in the Southern District. I find the rules are similarly disparate that way, and the Northern District tends to be a little bit sleepy. It's a nice place to litigate. The dockets aren't as crowded. Nice judiciary, and the rules are pretty loosey-goosey. So we have, again, in the Northern District, a 16.3 rule under local rules. It talks again about the things that the Middle District talks about, suggesting alternatives to litigation, analyzing issues, questioning perceptions. These are things we all do on a daily basis as neutrals, and it sort of sets out for those a aspirational tone. But I think that it really is very clear about us reporting to the presiding judge about whether a case settled or not. And I find sometimes it's funny that the ECF will call our reports result of mediation hearing or something like that. And I think that's just an antiquated docket entry. But of course, it's not a hearing. It's something that's confidential. It's something that parties really appreciate participating in, where they can have that setting and disclose things that would not otherwise be available to the court. And I think the referral to mediation in the Northern District is really one that's also something that they suggest getting involved early. It can be done at any time by request. Again, lots of federal district courts have CMOs that include a timeline depending on what track you're on, and those CMOs will often name us as the mediator sometimes 2 years in advance, and we'll have our case coordinators at the Upchurch firm make sure that they have that window in our calendars, and they'll touch base with you as attorneys and say, hey, you remember that CMO that was entered in 2012? Is that case still pending, and have you discussed a place, a time, and date for that mediation, so as not to be in violation of the case management order. And so what I'd say about district court litigation is mind your case management orders, the deadlines therein. They can also be used if you're not complying with those as a sanction to a party. And really what the whole process is about is staying involved and learning about the other side, really using the mediation, if not to settle the case, at least let us, help us help you all learn more about your case, and don't just huff out because somebody didn't comply with the letter of some requirement in a local road. And with that, I'm going to pass it on to Dom, who's got the beautiful Southern District of Florida, which has its own little set of rules for mediation. Dom?
Thank you. I'm going to basically go through all the rules of the Southern District, most of them rather quickly because they're really not different than the Florida rules. The 16.2 is the local rule, and basically Section A of that rule basically defines mediation, who can be chosen as a mediator, the certification of a mediator as it's done by the chief judge. It also does not allow for testimony by experts or anyone else at the mediation, nor can a mediator review or rule on a question of fact or law. I've had mediations in state court where experts will come in on difficult cases. Apparently under the federal rule or the local rule for the Southern District, they don't want to. That's not part of the mediation process. Also in the Southern District, we are required to report whether it's settled in full or in part, it's impassed or it's adjourned, and we are also required who fail to appear under Section E, and I'll talk about Section E a little bit further. And obviously it also goes on to say that it's a savior of saves judicial time, enables litigants to control their dispute, etc. Going to Section B, the Chief Justice in the Southern District certifies the mediator. The clerk is to maintain a mediation list online at all times for use by everyone. And the requirements in the Southern District is 10 years members of the bar and of the Southern District. You are to be in good standing the entire period of time, and you should have substantial experience as a mediator before you get certified. I'm not real sure what that means, but obviously it's there. One of the things that is different, at least in the Southern District rules, that is different than Florida, is that if you use a non-certified mediator, they are still required to subject themselves to the DRC rules of the Southern District. So they can still be held and sanctioned, whatnot, under the rules if they don't follow them. Another thing under Section B is the compensation to the mediator, which is basically split. One of the quirks in the Southern District is that the mediator is now prohibited from engaging in fee-shifting negotiations. Oftentimes in state court, plaintiff will agree to take the defense offer if they will pay for mediation costs. Well, now the mediator, or it has been now for about 1.5 years or 2 years now, in the Southern District, they are prevented from doing it. Their thinking was that they did not want to have the parties use the mediator as a wedge in the negotiation. So we are now precluded.
Do you find Dom, that compromises your neutrality when you get asked to
I really don't. I just go in and say, you know, are you willing to pay mediation fees? I don't know that I've had a lot of discussion and fighting over it, but you know, in the state court mediations that I've handled, but it doesn't appear that obviously in the Southern District that we're now precluded from doing so.
So how have you handled that situation, Dom, when it has come up?
I'm sorry, I can't hear you, Michelle.
Oh, how have you handled that situation when it's arisen in the context of your mediations?
If in the federal courts, I've just basically told them that I cannot handle it. I am according to the rules of the Southern District, I am not permitted to engage in that. And I can just put the lawyers together if they want to talk about it amongst themselves and make an agreement following the mediation. I wouldn't report it as part of a settlement, but I would allow, you know, obviously if the attorneys want to talk about it, there's nothing that I can do. But I can't be engaged in that particular part of the negotiations.
Okay.
Under Section C, every case in every civil case is to be mediated in the Southern District, and there are 13 exceptions. Types of cases that are accepted. I'll run through those real quick. They are habeas corpus cases, motion to vacate sentence under 28 U.S.C. 2255, Social Security cases, civil forfeiture cases, IRS summons enforcement, land condemnation cases, default proceedings, student loan cases, naturalization proceedings filed as civil actions, statutory interpleader actions, Truth in Lending Act cases not brought as class actions, letters rogatory, and registration of foreign judgments. So everything else in the civil court, all of the civil cases are to be mediated in the federal court, and even those can be ordered to mediation should the judge desire. 37. I'm sorry, that's the slide number. The order of referral generally in the Southern District requires that mediation to be conducted 60 days before trial. That doesn't always happen, and there can be consequences to that, which I will touch on in a minute. The parties should select a mediator within 14 days of the referral. If it can't be done, it's the plaintiff's attorney's responsibility to request the court to designate a mediator from the certified list. Another thing that doesn't always happen is that it is required under the rules that a confidential written summary be given to the mediator. Don't always see it. Plaintiff's counsel is responsible for coordinating mediation, and the mediation can be withdrawn by the court if deemed suitable. There's also a 3-day cancellation requirement that occur that is in the federal rules. It requires that a mediation be canceled if it's going to be canceled 3 days prior to the actual mediation.
Do you find that's practical, Tom?
It really doesn't. I mean, you know, and it also states in it that we're required to bill 2 hours if it's not followed. I don't know that, you know, that routinely happens. I know I don't do it, but I'm sure that it's something there, or we can bill. I guess it's not mandatory that we bill, but it's in the local rules for the Southern District. They've gone so far as to do that.
A disincentive to cancel, anyway.
Supposedly, yeah, I guess that's true. Party attendance required. The Southern District has again amended the party attendance required. They keep trying to fine-tune this thing. It was last amended December 1st of 2014. It basically states the same thing that was in the Middle District. It's unless excused in writing by the presiding judge, all parties and claims professionals shall be physically present at the mediation. And that's what the rule says. I really believe that what they are trying to do is make it as difficult for personal injury cases to be removed and or brought in federal court. I have personally litigated personal injury cases in federal court. They really don't like it there, but I think that's part of what that rule is about. They have also gone into not personal counsel, but staff counsel, general counsel of corporations. They cannot act as all the parties. There must be at least two. So if there is a general counsel or a staff counsel, they can be either the representative of the company or the attorney, but then they have to have one other person to act as the other person when coming to mediation.
Unlike the middle district, you don't have the discretion to overlook the attendance.
Right. There doesn't seem to be that discretion, and there's a requirement, and I'll get that in the next section. I'll touch on it right now. In my mediation report, I am required to report who's there. I think if someone will come and say to me, well, look, we've agreed not to, someone doesn't have to appear, well, that's great, but unless it's in writing, and I presume that's by court order, I have to report that to the court. I had that occur right after the rule went into effect in early January. I advised the court that the claims professional did not appear live. The case settled. I don't think anybody ever heard anything from the judge about it. I had another case where I was required, the attorney for the defendant wanted me to make sure that I advised the court that the corporate rep also had the authority to settle the case and that there was just the two of them. So, then I've had...
I want to just jump in here just for a minute. Even the mediation disposition reports are different in state court than they are in federal court. Particularly in the middle district, they have a specific form that's online that they want their mediators to use, and it does have a designated area for the mediator to list who was actually present at the mediation.
It also uses anymore.
I don't know who that was. I think it was Lawrence. I don't know if there's something wrong with you.
I think we've been told to report no agreement, but you'll find our platform, the ECF, regardless of that.
Uh-oh, there's some major interference. I don't know. It's just now come into play. There's an audio issue with your microphone, Lawrence, just to kind of give you a heads up. Everything you're saying is really broken up. So, Dom, is there anything else you wanted to tell us?
Yeah, there's a couple more things that I was going to touch on. We have 7 days to report, and like I said, there's actually even a section for us to recommend to the court sanctions if someone doesn't appear. As a mediator, I just find that totally out of my of anything that I'd ever want to do or do, but the rules actually even contemplate that being done, and I've never heard of any mediator ever doing that. But the only other thing, I will skip over some of these reasons. They're pretty much the same as the state court on why a mediation can be adjourned, and the court has gone to great lengths in the Southern District to say what is and isn't confidential, and they keep amending it, and they want to make sure, and basically under the federal court, under the Southern District, they say that all proceedings of the mediation shall be confidential and are privileged in all respects as provided under federal law and Florida Statutes 44.405. The proceedings may not be reported, recorded, placed into evidence, made known to the court or jury, or construed for any purpose as an admission against interest, and a party is not bound by anything said or done at the conference unless a written settlement is reached in which only the terms of the settlement are binding. So they went in, they updated that particular provision a couple of times, and they just basically want everything in the world to be privileged other than the terms of the settlement.
Yeah, it looks like they went through great effort to ensure confidentiality.
Yeah, they
Well,
did.
I think, yeah, go ahead, Dom.
No, I was just going to say they did. And I think the only other thing I would say about attendance at these mediations, that new rule was, I think they wanted everybody to be there in the rule that they passed 2 years ago. They redid it again on December 1st. My guess is they did it for a purpose, and I think we're only 3 months into it, and my guess is that there's going to start being sanctions and whatnot for those not personally attending mediations.
Well, I want to thank all our participants today. Unless, Tom, you have anything else you want to add, I think we've reached the conclusion of our time limit and the conclusion of our presentation. Is there anything else you wanted to add, Dom?
Not really, no. I think we're fine.
Okay.
Thanks,
well,
Michelle.
I wanted to thank our participants today, Lawrence and Dominic Brandy, and I want to make you folks aware of the Florida Bar course number up there. It is 150, just for those who might not have the visual. It's 1501028N. N as in Nancy. Again, it's 1501028N as in Nancy. And also I want to give you kind of a little bit of an update from our firm. If you want to keep up with some of the upcoming webinars on our website, they will be posted there. You can receive notification from the website. And we have a webinar scheduled for March 26th, which is our next one. Brandon Peters and I are going to be presenting, and I'm going to let Brandon run the slideshow this time. And Brandon and I are going to be presenting the topic of why hire a full-time professional mediator. So I just want to offer one more thanks again to the University of Florida Levin College of Law Institute for Dispute Resolution as our sponsor, and thank each of you for participating today. I hope that you enjoyed the webinar and that you learned a few important rules that will guide you as you move forward in your litigation and in your mediation practice. Thanks again for joining us.
Have a great day, everybody.
Have a good day.
Bye now.
Bye.